nor the precise nature of the assistance which they gave to the murderers. In 2019, the United Kingdom Supreme Court held that Mrs. Finucane had a legitimate expectation that there would be a public inquiry into Mr. Finucane's death, and made a declaration that there has not been an Article 2 compliant inquiry into the death of Mr. Finucane. As you know, Article 2 of the European Convention on Human Rights give rise not merely to a duty not to kill people, but where there has been an issue as to whether the state had broken this obligation, there is also an obligation on the part of the state to carry out an effective official investigation into the deaths. It has been well established by the European Court of Human Rights that any information or material which has the potential to undermine the conclusions of an earlier investigation or to allow an earlier inconclusive investigation to be pursued further would prompt a revival of the procedural obligation. The need for an effective investigation goes well beyond facilitating a prosecution. In order to be compliant, an investigation must be capable of leading to the identification and punishment of those responsible. This must involve having the means to identify those implicated in the death. As yet, the British government has failed to respect the declaration of its highest court to provide a public inquiry. And under the controversial terms of the Northern Ireland Troubles, Legacy and Reconciliation Act of 2023, which provides an amnesty for British soldiers, any prospect of this happening is shut down. That said, there's a strong campaign by victims groups and human rights organisations to repeal the Act, and many of you will be aware of the Irish government taking the rare and unusual step of an interstate case against the UK government for breaches of Article 2 and 3 of the European Convention on Human Rights, amongst other arguments. Indeed, I attended the UN's Human Rights Committee's interrogation of the UK's human rights record in March 2024 to advocate for repeal. The committee's concluding observations agreed with my position, stating that the committee calls on the state party to repeal or reform the Northern Ireland Troubles, Legacy and Reconciliation Act 2023, and to adopt proper mechanisms with guarantees of independence, transparency, and genuine investigation power that discharge the state parties' human rights obligations and deliver truth, justice, and effective remedies, including reparations to victims of the Northern Ireland conflict. I'll now move on to speak about Rosemary Nelson. Rosemary was an Irish solicitor who was killed with a bomb planted in her car by a British loyalist paramilitary group in 1999. Rosemary Nelson received death threats from members of the Royal Ulster Constabulary, the illegitimate and sectarian police force in the north of Ireland, which operated with impunity during the Troubles. She received these death threats as a result of her human rights and legal work. Some RUC officers made abusive and threatening remarks about Rosemary to her clients, which became publicly known. In 1998, the United Nations Special Rapporteur on the independence of judges and solicitors noted threats from the RUC in his annual report and stated in a television interview that he believed Rosemary's life could be in danger. He made recommendations to the British government concerning threats from police against solicitors, which were not acted upon. Later that year, Rosemary testified before a committee of the United States Congress investigating human rights in Northern Ireland, confirming that death threats had been made against her and her 3 children. On the 15th of March, 1999, Rosemary Nelson was killed by a bomb placed onto her car outside her home in Lurgan, County Armagh. A loyalist paramilitary group calling itself the Red Hand Defenders claimed responsibility for the murder. Allegations that the British state security forces were involved in her killing led to a public inquiry, which concluded that it could not exclude the possibility that individual members of those agencies had helped the perpetrators. Furthermore, the inquiry found that Rosemary Nelson had been publicly threatened and assaulted by RUC officers in 1997, and that those officers had made threatening remarks about her to her clients, which became publicly known. It concluded that this helped legitimize her as a target in the eyes of loyalist terrorists, and some RUC intelligence about her had leaked. All of this, it said, increased the danger to her life. I'll now give some reflections. The life and death of Ebru remains an inspiration to me and many other socialists, some of whom are lawyers in Ireland and Britain. In terms of my reflections from the Irish experience for this conference, I believe that the peace process in Ireland was accelerated in a profound manner by, firstly, the sacrifice of Bobby Sands and the other hunger strikers who helped to inaugurate the revised political strategy of Sinn Féin, which ultimately led to the ceasefire by the IRA. And secondly, the deep respect and desire of our people for human rights, embodied in the work and spirit of lawyers such as Patrick Finucane and Rosemary Nelson, who sought to hold the British government accountable in court and in public opinion in Ireland, Britain, and internationally. Ebru's life and death brings both of these factors together in a profound and powerful symbol of justice, and it is right that she be honoured in this conference. It is ultimately the people we represent that will achieve justice, and it is our obligation as lawyers to do what we can to help them in the process of achieving it. In conclusion, Irish and Kurdish lawyers come from the struggle against imperialist and capitalist oppression by British and Turkish forces. Lawyers acted in defense of their clients and paid for it with their lives. Let Ebru continue to inspire you in your struggle, as Patrick Finucane and Rosemary Nelson have inspired me and other human rights lawyers in Ireland and further afield. Bobby Sands said, "Everyone, Republican or otherwise, has their role to play in the struggle for Irish freedom. My father was imprisoned by the British government for his role in the struggle for Irish independence, and I honour his sacrifice for my family, especially his grandchildren who now know peace and laughter. My role today, during a time when there is an agreed peace process between the interested parties in Ireland, is very different from that of my father. It is my responsibility to show solidarity with lawyers and activists who are putting their lives on the line for human rights and freedom in countries including yours where the struggle continues. That is why I am proud to stand with the People's Law Office, especially my dear comrades Gunay and Cherin. Bobby Sands also famously stated that our revenge will be the laughter of our children. I wish you peace with justice. I truly believe that for Kurds like the Irish, your revenge will be the laughter of your children. Keep up the struggle, comrades. You shall overcome. Solidarity and love from Ireland.
Thank you very much, Declan. It was very great, the intervention about combine the struggle of Irish Republican prisoners and Bobby Sands and the huge struggle that he gave with all the prisoners in H Block against the repression of the British occupation, and all this historical struggle that it was mentioned internationally for all over the world, that the Irish political prisoners, the Irish Republican political prisoners, felt martyred inside the prisons because they fight for the statue of the political prisoner, the fight against wearing the suits of the political prisoners, the fight for justice against occupation, and that's why they're standing in the history in the top of the hill. And it was very good to combine with lawyer Brotimtik that she made the same, actually. It was the same. It was mentioned now, everyone will mention in the history as a lawyer that sacrificed herself, murdered by fascism and imperialism, because she made a hunger strike resistance, a death fast, for a fair trial, something like a, not personally, something like a right that won by the people of the world through a very hard struggle, class struggle. And this is really important that mention as this. And in the same cadre is also Helim Bölek, Ibrahim Gökçek, that they felt also martyrs in a hunger strike for their concerts. In this way, we face all the history. And the Bobby Sands Brotimtik is in the side of the people, that they sacrifice themselves really for the justice for all the oppressed people of the world. We thank again Declan, and we give the floor to Thomas Schmidt. Thomas Schmidt will be also in Zoom. Thomas is a lawyer from Germany. Is co-secretary of the ELDH. ELDH is European Lawyers for Democracy and Human Rights. And we have now his participation from far away, and we are really very happy that he is, even by Zoom, but he is here, participant of the symposium. Hello, Thomas, you can take the floor.
Well, thank you very much. Good morning, dear colleagues. Many thanks to the organizers of this symposium for inviting me to speak here. I'm delighted to have this opportunity and regret that I cannot be here in person in Athens. I have many memories of Ebru Timtik, to whom this symposium is dedicated, from her work as a lawyer, which was always also a political activity. I will never forget my visit to her in prison. Her death fast for fair trials will remain unforgotten for all of us. In this context, I do not want to leave unmentioned the numerous other CHD colleagues who have been victims of arbitrary political trials, some of whom have been imprisoned for years. Among them are Selçuk Kozaklı, Özgür Yılmaz, Bakin Timtik, Engin Gökçeoğlu, Ayşat Çiçek, Aytaç Ünsal. I had already met Selçuk Kozaklı before the CHD became a member of EADH in 2007. I've also worked with Aytaç Ünsal for a long time. When Selçuk Kozaklı was awarded the Hans Litten Prize by the Association of Democratic Lawyers in Germany in 2014, he was unable to accept it in person because he was banned from leaving Turkey. Aytaç Ünsal and Münip Ermiş came to Berlin to accept the award on Selçuk's behalf. Together with Ibro Timtik, Aytaç Ünsal participated in a 214-day death fast during his imprisonment, which he ended after being released from prison, at least temporarily, for medical reasons. A new attack on CHD lawyers occurred in Istanbul in February this year, following a shooting in front of the courthouse. Our colleagues Betül Van Gölü, Kozaklı, Seda Saraldi, and Didem Bayda Ünsal, who were arrested in February, are still in prison. I also have a long-standing political cooperation with numerous speakers. I would have liked to see them again on this occasion. I'm comforted by the certainty that there will be plenty of opportunities for joint struggles in the future. It is characteristic that this conference is taking place in Greece. This is certainly not because there was no conference room available in Turkey, nor it is because the Greek government has a particular friendly relationship with the People's Advocate Office or People's Law Office. It is well known that the two governments form a questionable alliance in the prosecution of alleged terrorists, which does not stop at the prosecution of the defense lawyers of alleged terrorists. The topics of this conference also represent a major challenge for my organization, the European Association of Lawyers for Democracy and Human Rights, EADH, and for our member organizations and partner organizations. In our legal policy work, we, our member organizations and partner organizations, are constantly confronted with these issues. It is no coincidence that our German member organization, the VDJ, the Association of Democratic Lawyers, has given its commemorative publication of the 50th anniversary of its foundation the title Dispute About the Law, Legal Policy Battles in 50 Years. The EADH has member organizations in 22 European countries, including 2 member organizations in Turkey, the CHD, Progressive Lawyers in Turkey, and the OHD, Lawyers for Peace. Our colleagues in Turkey are among the most active. This is demonstrated not least on 24th January every year, the International Day of Endangered Lawyers, when numerous rallies are organized in Turkey in solidarity with endangered lawyers elsewhere. Our second Co-Secretary General, Sheriff Şerin Ünsal, is a lawyer from Istanbul. We encounter the deformation of the law in various forms in our work. Governments, transnational state organizations such as the European Union, large multinational companies, and the capitalist neoliberal economic order are responsible for this. We can often speak of a perversion of the law, for example, when the judiciary is abused by governments to immobilize political opponents and their lawyers. In Turkey, the number of political prisoners has multiplied as a result. Many lawyers from the CHD, the OHD, and the People's Lawyers Office have become victims of this arbitrariness. However, it can be difficult to describe and agree on what constitutes deformation. This word requires agreement on which rule of law is considered non-deformed or desirable. The deformations could also be seen as a result of social struggle that have ended to the disadvantage of the working class. For me, deformation is the gross violation of generally applicable human rights norms, as well as the framework conditions that contribute to this. Now some examples of the deformation in this sense. Violation of the principles of a fair trial. The indeterminate legal concepts used for the arbitrary prosecution of political opponents. This includes, in particular, the accusation of terrorism, often based on inadmissible evidence. Thousands of political opponents of the government have been charged and convicted of supporting, joining, or leading terrorist organizations. Violation of the UN Basic Principles of the role of lawyers, the so-called Havana Principles, in particular Article 18. The lawyers shall not be identified with his clients or his clients' affairs in the performance of his duties. In fact, in almost all cases, CHD defense lawyers are identified or have been identified with their clients. Criminalization of refugees and their supporters. And another point, unclear or missing legal provisions to protect refugees against violations of fundamental rights. This has also been repeatedly criticized by the CPT. Now the role of the judiciary. The role of judges is only neutral in the sense that they are obliged to apply the applicable laws impartially. As we know from Turkey, for example, the role of judges is at best formally neutral and independent. In this way, judges contribute to the deformation of law. The lack of independence in the Turkish Constitutional Court. A particular deformation problem of the Turkish judiciary is the disregard of the decisions of its own Constitutional Court and the European Court of Human Rights. The lack of independence is already the result of the election of judges over which the president has a decisive influence. Nevertheless, the court has made decisions in a few cases that were not in line with the political objectives of the Turkish president. At the beginning of November 2023, the third chamber of the Supreme Court of Criminal Appeals, Yargıtay, announced that it would not recognize a ruling by the Constitutional Court, and it had filed criminal charges against 9 Constitutional Court judges who had signed the judgment. The Constitutional Court has exceeded its powers, reads the letter from the lower court. As a result, the Public Prosecutor's General Office investigated 9 of the 15 Constitutional Court judges. The accusation obstruction of justice. And at the end of October, the Constitutional Court granted parliamentary immunity to a member of the parliament who was in custody and demanded his immediate release. In the view of the appeal judges, the decision is unconstitutional. The best known case of disregard of the decisions of the European Court of Human Rights was his order to release Osman Kavala. Turkey was also reprimanded for this by the Parliamentary Assembly of the Council of Europe. Another deformation is the privatization of the judiciary. Transnational agreements are typical result of neoliberal policies. They regulate the free movement of goods and services and often contain investment protection agreements. Examples include free trade agreements within the framework of the World Trade Organization, TTIP and CETA, and others. There are more than 3,000 investment protection agreements worldwide. The investment protection agreements favor multinational companies from large industrialized nations when they invest abroad. Investment protection goes so far that the economic interests of the investors take precedence over labor, social, or environmental regulations. In the event of a conflict, investors are entitled to injunctive or compensation claims. A large number of transnational trade agreements provide for private arbitration tribunals to resolve disputes. The European Court of Justice considers such private arbitration tribunals to be inadmissible if the agreement was concluded between two member states. Otherwise, the establishment of a non-state court is permissible as the associated undermining of labor law, environmental or other social regulations. Another deformation is the role of the public prosecutor's office. Public prosecutors also work on the instruction of the government in many countries. At least in the EU, this contradicts the applicable legal provisions. With reference to the external right to issue instructions, the European Court of Justice denied German public prosecutors the power to issue a European arrest warrant, as they are not judicial authorities due to their lack of independence. This was a judgment from 2019. The lack of independence makes the public prosecutor's office vulnerable to arbitrary political decisions by the government. Now I come to the role of lawyers and their contribution to the deformation of law. Under what conditions must we, as progressive lawyers, practice our profession today? A lawyer's work is not neutral. As a rule, they are not concerned with realizing an abstract legal principle. Legal training is also not neutral, but ideologically influenced. It is where the deformation of the law can begin. The legal system and the applicable laws are not neutral either. They are the result of the respective balance of power. Only part of the legal system regulates the relationship between labor and capital. Only some laws strengthen the role of labor, many laws weaken their role. The activity of a lawyer can be compared to that of an arms dealer, regardless of whether he is practicing his profession out of commercial interest or whether he is working for one side or the other out of political conviction. As long as the lawyer restricts himself to applying the applicable laws in favor of his clients, this is legal. Nevertheless, defense lawyers in many countries, including Turkey, experience that they are identified with their clients for precisely this reason. They are accused of complicity with their clients. In Turkey, numerous lawyers from the CHD, the People's Lawyer's Office, and the ÖHD have been sentenced for this. Among them is also, or was also, our colleague Ebru Timtik, who died while in prison as a result of a hunger strike to fight for fair trials. The authorities refused to temporarily suspend her detention for medical reasons. It was only when her colleague Aytaç Ünsal was threatened with the same fate after 214 days of death fasting that he was at least temporarily released from custody. The latest victims of this unlawful criminal practice were again 4 other lawyer colleagues of the CHD and the People's Lawyer's Office, Didem Bada Ünsal, Barak Chaya, Seda Saraldi, and Betül Vandiolu Kozachlim. We are encountering a further deformation of law through the legal policy activities of large law firms. The role of large law firms can be a great danger for the rule of law. Influence on law preparation. Large law firms are commissioned by ministries to prepare draft legislation. They influence the ongoing legislative process on behalf of clients. Legislation is therefore no longer the result of a democratic process, but the result of the work of large law firms controlled by large corporations. Influence on specialized literature by large law firms. A considerable proportion of publications in specialized literature are written by lawyers and large law firms, by professors commissioned by them. Progressive lawyers hardly have a chance to publish to anywhere near the same extent due to time and financial constraints. These publications have a considerable influence on the decisions of the courts, which like to refer to an allegedly prevailing opinion of the legal profession. This prevailing opinion is nothing else than the opinion of the influential large corporations. The influence on the judiciary. In addition to the normal legal activities, large corporations also influence court decisions in other legal ways. The preparation of extensive expert opinions to influence court decisions can exert an important influence on court decisions. Smaller law firms and these less financially strong law firms can only afford to do this in exceptional cases. By inviting judgments to seminars and conferences, large law firms organize specialist seminars for the further training of lawyers and administrative lawyers. Judges are often invited as speakers, sometimes for considerable fees. This intentionally or unintentionally creates dependencies. Judges can also be indirectly influenced by the discussion at these seminars. By lobbying parliaments nationally and on the level of the European Union on behalf of their clients, law firms are also very active. I give you an example. Freshfields Bruckhaus Deringer is one of the largest commercial law firms in the world, specialized in mergers and acquisitions. It employs a total of around 2,800 lawyers, including over 600 in Germany. Freshfields is one of the pioneers in the entry of law firms into the lobbying business in Germany. Its lobbying activities relate in particular to the areas of tax legislation, regulation of financial flows, direct investments, and international arbitration. In recent years, the firm has involved in the drafting of important legislation, particularly during the financial crisis. This form of legislative outsourcing has been repeatedly criticized. According to the firm itself, a large part of its work consists of influencing EU legislation in the interest of its clients. In the EU Transparency Register, Freshfield states as in 2023 that it spent around €1 million on lobbying activities in 2022 and employs 16 lobbyists. Clients in 2023 included associations of Bermuda insurers and reinsurers, Airbnb Ireland, and PayPal. Now I come to the role of progressive lawyers and their possibilities and their efforts to counteract against the deformation of law. Well, one important, since the progressive law firms don't work on the same scale as the large law firms I've been describing, the ELDH, the AED, and the IADL try to counteract the deformation of law by initiating transnational networks and corporations. Examples of this are to reveal human rights violations by governments which claim to be the guardians of human rights. Another important example is the Day of the Endangered Lawyer. On 24th of January every year. This year it was dedicated to the lawyers in Iran. The International Day of Fair Trials, the 14th of June. This year it's dedicated to the Philippines. The fact-finding missions and trial observations in Greece, Malta, Turkey, Ireland, to the Philippines, Hungary, and other countries to investigate human rights violations. The European Network of Labor Lawyers, current focus, the preserving the right to strike, and publications of investigation reports and statements, human rights violations, in particular against lawyers. Lawyers' organizations from all over the world participate in these various formations. All participants at this conference and the organizations they represent are called upon to take an active part in these activities. I wish the organizers and the participants at this conference will contribute to overcoming human rights violations and arbitrary arrests in Turkey, Greece, and other countries, and especially that the imprisoned lawyers will be released immediately. I send my solidarity greetings to our imprisoned colleagues. The fight for their release is our duty of solidarity. Thank you very much.